We are live.
Good morning. It's February 17th in Senate Judiciary. We're taking up the new version of S-193, and we have Ledge Counsel here with us to do the walkthrough.
Good morning. Thank you. Nice to see everybody. Eric Fitzpatrick with the Office of Legislative Counsel. As the chair said, here to do a walkthrough of a possible proposed committee strike-all amendment to S-193, which is an act relating to establishing a forensic facility for certain criminal justice involved persons. The new draft you'll see is quite a bit of yellow highlighting on it, but I'll mention as I go through, not every instance of yellow highlighting is necessarily changed language, because I highlighted a couple of places where it was just questions that the committee had yet to reach a final resolution on, but I think the committee had indicated last week that you were still thinking about those, so I'll point those out as we go through so that you can keep thinking about them today and later in the week, whichever makes sense. So, but in other cases, there's new language that's highlighted, and you'll see the first one of those on page 1. Actually, for just 2 seconds of background, if you're kind of refresh everybody's recollection about the forensic facility. Remember, the idea is that this is a facility for 2 groups of persons. So there's essentially 2 tracks of people that are coming in. People that have been found incompetent to stand trial, and another group of people that have been found not guilty by reason of insanity, which is sometimes referred to as NGRI, not guilty by reason of insanity. And those folks are often referred to as criminal acquittees. So they've been found not guilty by reason of insanity. Now, not all of those instances go to the forensic facility. They're only with respect to certain offenses. Offenses with a maximum penalty of life in prison, and if the person isn't already subject to the civil commitment as well, then they would go into the forensic facility under the bill. Actually, that concept is the same as the bill was introduced in the version that you're looking at now. And in fact, I think it might help before we even go to the first page, because you may recall that key here is the definition of the forensic facility, and that's on page 9. So if you take a quick look at the highlighted language on page 9, or at least the first part of it, that's lines 5 through 13, right? So here's the forensic facility being defined. Now, the substance isn't really different than the previous draft that you looked at, but it's been reorganized, because I think the committee's concern was this notion that it seemed like treatment wasn't really being highlighted here, that the purpose of the facility is treatment. So I set out the 2 subdivisions A and B separately so you can see what they both were, and reversed the order. So you see the first one that comes A, forensic facility means a locked facility or placement that the Department of Corrections provides for the secure evaluation, treatment, and care of persons involved in the legal system who do not require hospitalization medical care. So very first thing that comes up front is the fact that it's evaluation, treatment, and care. And there's a constitutional basis for that, because generally speaking, someone can't be essentially committed without some basis. And then the basis for the commitment generally is the fact that someone has a mental illness, and there's some other factors that we'll talk about. So the idea is that the person can't just be housed indefinitely without some treatment of the underlying condition. So again, that doesn't change the substance, but it reorders it so the treatment is being highlighted up front in A. B, though, second is that the placement is required for the custody, control, correctional treatment, and rehabilitation of persons transferred pursuant to, and then it's got those 2 cross-references, and those are the 2 that we're going to get to, the incompetency and the NGRI, not guilty by reason of insanity. Lastly, in the definition, you'll see lines 11 to 13. This is just some language, and this you may recall from the previous draft as well, just setting out, in this case, it's permissive, not mandatory, but that these evaluations that take place under this chapter can be conducted pursuant to contracts entered into between the Commissioner of Corrections and the Commissioner of General Services and evaluation providers. And I think you're going to hear from witnesses from both departments later this week as to whether or not that process is going to work and how it will work. So that's the definition. So that's the facility. So then, all right, that's what the facility is. How does a person get into the facility? Let's turn back to page 1 for that. And this is your first group. This is the people found incompetent to stand trial. So you'll see there's 3. Again, I broke this out into separate subdivisions, so it could be more clearly stated who it is that that could be subject to the civil commitment process. I'm sorry, subject to the forensic facility. And so there's 3 criteria. First one, charged with an offense punishable by a life sentence: homicide, kidnapping, aggravated sexual assault, aggravated human trafficking. There's a number of offenses that have this maximum life sentence. So the person has to be charged with one of those.
Eric?
Yeah.
When you get a chance, can you get us a list of all the life offenses so
Yeah.
put it on the committee page and make sure everybody can review what conduct could potentially lead to this?
Absolutely. Will do. Yeah, sure. So, first, one of those offenses, person's been charged with one of those. They are not, and this is lines 14 and 15, they're not currently receiving treatment through an order of hospitalization. Now, that means, in other words, that's a reference to the civil commitment process, right? So they're not currently in the civil commitment process. In other words, this is important to remember as we get further into this bill. That civil commitment process is the one where the state has to prove by clear and convincing evidence that someone is a danger to themselves or others as a result of a mental illness. So that's in existing law right now. It's a civil commitment process, and that remains in law whether or not this is passed, right? So you have this forensic facility, it's sort of another track to a different type of facility, but the civil commitment process exists, and that also does apply to some crimes. Because remember, look at line 12 again, this is only for life sentences, right? So someone could get charged with, say, an aggravated assault, doesn't have a life sentence. That person could be found incompetent to stand trial or not guilty by reason of insanity. And because the way the law is set up now, the court holds a hearing for that person, decides whether or not they're a danger to themselves or others, and if so, they're civilly committed. So that all still exists, would still exist, I should say.
So just to clarify, would that be a hypothetical situation in which somebody is charged with domestic assault? They're found not competent to stand trial, but there's sufficient evidence to show that there's still a threat to that person, and they could be required to go for 10 days or 20 days to the Brattleboro retreat or some other hospital?
Yep, and that they could be ordered, if they're found that they're still dangerous, they would be ordered committed to the custody of the Department of Mental Health. And that's where they could end up at Brattleboro, or maybe they could do outpatient treatment. I mean, that clinical decision is still a medical one for the department. But yes, that's
something that exists now, and we're not touching that, essentially.
Not touching it, except that for people charged with a certain handful of offenses, these life sentence ones, they wouldn't go that route anymore.
Right.
They would go this route. They go to forensic. Exactly.
Senator,
just a quick wording thing on line 18.
Page.
This is page 1.
Oh, great, thank you.
The word often there seems unnecessary and seems to change the meaning to me. I understand it to be saying not less than the shorter of either every 6 months or upon the determination. Not less often doesn't seem to apply to either of the examples that follow. So I'm wondering if we can eliminate often, or is that a term of art?
No, it's not a term of art. It's really just, and I had the same, this was the language that Bill was introducing. I thought about it. You see, I did rework it in the not guilty by reason of insanity context, but in this one, I didn't, but it's not a term of art. I can rework it. I'll tell you what the intent is, and I think then we'll try and achieve the intent with clarity. But the intent is that the person, so let's say the person does get committed on this track, which is the found incompetent to stand trial for a life offense, and they're not already civilly committed on the other side. If that's the case, then they go right to the forensic facility for evaluate, and then they would have to have an evaluation either every 6 months or when they're deemed likely competent by the clinical services director. So that's the intent. But I think I agree with you that there's a better way to get at that. But that's the idea of what would happen. Because in this case, the person has already been evaluated because they had to be evaluated to be found incompetent.
I see. Now I think I understand better. So often does have a function there. In other words, there's multiple times they're supposed to be.
Yes, every 6 months. And that may not get there. When I read it after, it's funny, the first time I read it, I was like, it doesn't really say it. But then most recently when I read it, I said, well, I guess it kind of does say that. But maybe the fact that it took me twice is an indicator that it could be stated more clearly. But the idea is they go to the forensic facility on this track. They've already been evaluated once because they had to be found incompetent in the first place. And then, so they get there and then they have to be evaluated every 6 months. Or, that's what they're trying to say here, but not less often, because it's every 6 months, but they also have to be evaluated if the forensic facility's clinical services director says, we've reached a conclusion that they're likely competent now.
Yeah.
So that's what I think it means by whichever is sooner.
Okay.
The idea. That sort of concept clear. So that's what happens. The person under the proposal goes to the forensic facility. If they've met those criteria, and they're reevaluated every 6 months, or when they're found likely competent by the clinical services director. So that's what goes on. You can turn over onto page 2 now. Now, if they do get evaluated, either because it's every 6 months or because the clinical director thinks they're likely competent, what does the evaluation have to include? Well, at least at the request of a party, the court may order that the second or subsequent evaluation include a forensic risk assessment. That's lines 2 to 5, and then it describes what's in the forensic risk assessment. So that can be ordered as part of this either every 6 month evaluation or one at the request of the department. Moving on to subsection C, a little bit lower on page 2. Now remember, how long does the person stay there? Remember, under the previous version of the bill, it had been sort of turning on the person receiving a verdict in their underlying criminal case. Now the concept is clarified throughout this section. The person stays there, generally speaking, until competency is restored or the case is dismissed.
So, Eric, I'm curious about hold without bail status. Would they have the 7553 hearing? Actually, can you tell me when they would have that hearing in this process? So, for example, and so I'm wondering if somebody is restored to competency, do they go straight into a 7553 hearing, or is that done prior? And I'm just curious your thoughts on that.
I honestly don't know. And I think that one thing to sort of keep in the back of your minds here is that this forensic facility process is entirely new. It doesn't exist in Vermont right now. So a question like that, in some sense, I think you could put language in here that whatever you felt was the best policy.
Yeah, I don't want to cause extra confusion in all of this. If this process gets created, and I don't want to leave courts and the parties wondering, do we do the hearing now, or is it supposed to be done while competency is being restored? And so I do think some language around there so that it doesn't cause confusion in future cases would be good. So,
and does it make sense that the bail hearing wouldn't need to take place until competency was restored? Is that the idea?
No, I mean, you can still have that hearing beforehand. The burden is on the state to prove the elements as to whether or not somebody is going to get held without bail.
Right.
So yeah, it's a good question that we're going to have to take some additional testimony on.
Right. The interaction there.
Yeah. Senator Bowles.
I'm curious, if the person's not competent to engage in their defense, how would they be competent to engage in the bail hearing? I don't understand how we can put any hearing or any legal process before competency restoration.
Competency to stand trial.
Right, it's a different thing, and it could be that if the state is seeking seeking a hold without bail, perhaps it would fall on the person's counsel to contest that, but it may be that you're right, that because competency is a threshold issue. So it may be that the court might say that until competency is established, we wouldn't have that hearing. Because in theory, I suppose the person wouldn't be, well, this is the question about the interaction of it. Might it be that the person isn't being held without bail because they've been committed right to the facility? So that process, in a sense, has been interrupted. they're not being held under 7553. Again, since this is brand new, I'm not saying I know this, I'm just trying to think through it a little bit. But it might be a good one to think through with Judge Zone or Domenica from the Attorney General's office as to how those two processes would interact.
What is the order of operations?
That's a good way to put it, exactly.
Thanks, Senator.
Quick question about, this is the bottom of page 2.
Mm-hmm.
The person's refusal to receive competency restoration services shall not be grounds for release or dismissal from the facility. I don't know how uncommon or common it is for someone to refuse competency restoration, but if they did and they continued to, because this is a facility with very few beds, would it be that the person just exists there for an indefinite period of time?
Well, it's possible, but not necessarily so. Charges could be dismissed, so
Yeah.
that's one option. And I suppose that it's possible, I'm not a medical expert, but I would think that it might be possible that someone's competency might be restored even if they didn't receive the services.
But if their competency wasn't and they refuse, could they be there 5 years?
Yes.
10 years?
Yep.
Okay.
That's the way it's written.
I mean, the alternatives are, involuntary competency restoration.
Well, you could, there is going to be, for example, if that might include involuntary medication, for example, and that is provided for on page 3. So yeah, that could be something that would happen.
Okay, thank you.
Yeah.
I think that also reminds me that this has to take a swing through health and welfare as well if we're talking about medication.
Yep.
Just a general note.
Right. Yep. Before we turn to page 3, though, just one last thing to note on line 17 of page 2. It's another, remember the committee also talked about this last time, is to make sure that these competency restoration services are provided. Because previously the language had said may, and you wanted to specifically require that these things are provided to the person. And so the may has changed to shall in a couple of different places. All right, so then the next question is, all right, so if competency restoration services are being provided, how long would they be? That's over on top of page 3. How long are they provided? They are provided at the forensic facility or at another location as per the discharge plan, starting on line 3, until the person is restored to competency or until the charges have been dismissed. So again, that's how long they're there, and that's how long they have to be getting services as well. So they're getting the services the whole time. The last subsection F, Senator Bruce, just sort of mentioning this piece. This is the involuntary medication language. Commissioner has to receive prior approval from the criminal division for involuntary medication, and then there's a finding that's required before it can be ordered, and that's lines 11 to 14. That's from a particular United States Supreme Court case that lays out the standards of the United States, and that was actually, you may recall, the first version of this draft of the bill, or not the first version, a previous version, specifically referred to the case. And you may recall Katie mentioning that we don't usually just say the standard under this case. We track the language from the standard and reprint that in the statute. So that's what this is. That language is from that case. It's an involuntary medication constitutional standard.
Senator Burlesky?
Are there other instances where we do involuntary medication? Or would this be the only instance in which that would be allowable?
No, it's under, I'm not gonna be able to provide detailed answers because that's Katie's area, but yes, under Title 18, there's a specific statutory language as to when involuntary medication is permitted.
Okay, and does that also go to the criminal division to approve or not approve?
No, that goes to the family division because those are the civil commitment proceedings, so those aren't in the criminal court. That's when someone gets civilly committed to that process that exists now and which will continue to exist for some criminal defendants, because again, not all crimes have this life sentence. So this is a very specific group of people that are going to be subject to this standard. Well, subject to this process. The involuntary medication constitutional standard is the same in both cases, but different courts and different circumstances. So yeah, it would still apply to someone who's committed through the civil process in the family division, for someone who either it just happens, in the general public, someone petition can be brought to involuntarily commit someone, or it could have been someone who came in through the criminal process through a crime other than one of these life sentence ones. Does that make sense?
It does, and this is probably something to explore with the courts. I wonder about sort of splitting up and asking two different courts to follow the same. It seems to me it might make more sense to have the same court that does it, that has more experience with it, just do all of it. But maybe a question for the courts, especially when we're talking about a small subset.
Yeah, there's no reason that you couldn't, if the family division has the experience with the involuntary med situation, there's no reason that you couldn't say for subsection F, hey, if the commissioner wants to do this, they have to pursue that piece in the family division because they're the one that covers that issue generally.
Yeah, it just seems silly to me that we would recreate a whole process for a tiny group of people when the process already exists and maybe is working.
Right.
Just to clarify, is the kind of the underlying point or question, should it just be the family division that's doing the approval?
Yeah, that is the underlying question. Should the involuntary med orders just all go through the same process that already exists?
All right, so,
sorry.
sorry.
So I'm trying to figure out under what circumstances would anybody, the judge or the prosecutor, request a competency evaluation without the defense bringing this to the forefront? Who would request this competency reevaluation? And if they did, why would, if the prosecutors or the judge did, why would they do that if not upon request of the defense attorney?
You mean for someone who's in the facility?
At any point in time, who would request a competence restoration?
If the criminal case is ongoing,
Yeah.
and it's prior to any of this, prior to there have been a finding of incompetency, which could trigger them being sent to the defense. If we're still in that case, then competency can be raised by anybody. It can be raised by the prosecution, the defense, by the court on its own motion. Again, it's that whole idea that competency is this threshold, this issue. It's unconstitutional to try somebody who's incompetent. So if any of the parties in the court has a reason to think that that the person might be lacking competency, they can request an evaluation before this even happens.
So how often would that happen? Or you probably don't know that answer. That the prosecutor or the judge would request this without the defense requesting it first?
I don't know the answer to that. It's a good question, but you probably want to ask the Department of State's Attorney,
And why?
Sheriff,
You know,
and Defender General Court, who most often requests this.
In my brief experience, I can say it's generally the defense that raises competency as an issue. There are circumstances where the person is coming in for the first time at arraignment and all three of the parties, well, the two parties in the court are seeing the person, and there may be a bench conversation where everybody agrees potentially that it makes sense to have a competency evaluation. But I would say generally speaking, in my brief experience, it's mostly the defense that raises it.
and that would back to Senator Postie's question as to if it's a defense, generally speaking, asking for the competency evaluation, then we start looking at bail. If the defense has a question as to whether or not they may be competent, how would they be competent to stay and picking up on a particular piece of it, obviously, so.
It'd be an interesting question for either the Defender General or the state's attorneys. Like, how does that process work now? Because it happens plenty that competency is raised. So how do they deal with bail? Do they, and I don't know the answer, but do they defer that? Because as you point out, maybe there's no basis to ask the person to participate in a bail hearing if they're incompetent, so maybe they set that aside the same way they defer the trial. They don't proceed with trial, they can't constitutionally.
And I know we all know that they have a right for a bail hearing, but if their competency is in question, then that kind of convolutes the waters a little bit, I would think. So I'll have to ask those individuals as they come in.
Yeah, it's a good question. there's a separate section, so we're kind of transitioning now. That's sort of the end of the competency way to get into the forensic facility. Now, section 2 deals with a different issue related to competency. Now, this is the language that's proposed to be added that essentially adds or takes some findings of incompetency and dismisses them. So if a person has been found incompetent to stand trial for a misdemeanor, right, got to be a misdemeanor, if the case is inactive for a period that's either equal to or greater than the maximum sentence, then the court dismisses the case, unless the court finds that dismissal would be contrary to the interests of justice. So that's this process, this idea that you'll hear from witnesses about this, I expect, but from what I've heard anecdotally is that there's many of these cases sort of hanging around, and that there have been incompetency findings that are old on the books, and in an effort to dismiss some of these cases that aren't active anymore, this would permit that.
Senator Bose, do you have a question?
I can wait until the right people are, and I don't think it's a question for legislative council.
Right. There's a highlighted language there, you see line 2021, because that's an unresolved issue that the committee has heard different testimony about. Should these dismissals be with or without prejudice? In other words, should the prosecution be permitted to refile them or not? If it's with prejudice, they can't. If it's without prejudice, they can. And I think you've heard different points of view as to whether or not that's the right result. Pure policy question for you.
Before we move on, what are the committee's initial thoughts on that?
With or without?
With or without?
In line with our thinking about and efforts to reduce the backlog, it seems like if it's a misdemeanor offense and it's been hanging around for years, and there's the possibility that the court could extend it anyway, it seems like with prejudice makes sense to me.
I would follow with, I don't necessarily have a problem with that, but I think we have to take, are the victims involved in this also? And we have to certainly take them into consideration when we're looking with or without.
Wouldn't the court do that? So in other words, it says,
It should do that, I don't know if they would or not.
Well, I mean, that might qualify as in the interest of justice for extending it.
if the court, so the court has to do a finding, either that it is or isn't in the interest of justice to let it go?
I think the way I read that, the finding would only be required if the court if they don't dismiss.
But the court, it would be brought to the court's attention that they either have to move or lose the case.
Correct. Yep.
So in that moment, I would think if there were victims involved, the court might bring that into a hearing.
That would be the situation in which I think the way the language is written, the court could think about that.
Yeah.
If they felt it was a situation where.
You're maybe thinking we should require that?
I was gonna say, yes, I don't have a problem with prejudice as long as the court takes into consideration any victims or damages accrued from the alleged crime. Shall take this into account.
Maybe a question for the state's attorneys or the victim's advocate, but I'm wondering if victims have access to whatever is available from the victim's advocate, regardless of where the case is in process, right? Like
Right.
a crime has occurred.
Yep.
Any victims get access to whatever probably could be beefed up, what services and supports are available to victims, but they have access to that, whether or not someone's convicted, whether or not someone, like that, right?
Yep, that's
Okay.
all in the statutory list of the info that they get.
Okay.
But we did hear testimony from, in reference to survivors of those who had their lives taken, that did not necessarily work. The advocacy program didn't necessarily work as far as the notifications they were receiving or not receiving, is my concern here. I just want to make sure the victims or the survivors are taken care of. That's my concern.
Sorry, were you gonna respond?
No, I was just
Senator Rose.
Yeah, I mean, this language only applies to misdemeanors, so not to say there aren't victims of misdemeanors, but it doesn't apply to the bigger cases like we were hearing about the other day. And I would agree with you, Senator Norris, 100% that we should give more resources to our victim services department. I think that they generally do not have what they need to be able to do the adequate work of taking care of victims of crime. So, but this language, Eric, correct, is only for misdemeanors.
Correct.
Okay.
So I do hesitate, making it with prejudice. I actually prefer without prejudice in thinking about, for example, multiple instances of stalking or say disorderly conduct by telephone or even domestic assault that is a pattern of conduct against one individual over the course of multiple years and then leads to a kidnapping charge or leads to a murder charge or an aggravated sexual assault charge. And then getting to that point and not being able to take into consideration or not being able to bring back cases that were dismissed with prejudice. So at the moment, I'm more inclined to have it be without prejudice, but happy to be persuaded otherwise.
Sounds good?
Any other opinions on that?
No, I guess my question would be, if it's dismissed with prejudice, and using the chair's example, if in fact another case came up down the road, could they still go back and use the alleged offense in what you're talking about as far as if it's dismissed with prejudice?
No, you can't bring the charges back. I mean, depending on what evidence there is, you might be able to get character evidence in that's related to the case, and other types of evidence as well. But it's a pretty specific question. But you wouldn't be able to refile the charges. But if there's evidence that exists from the past, I don't think that it would be prohibited from, or it wouldn't be inadmissible if it's relevant to proving whatever the new charge may be.
So then I would lean toward without prejudice. If in fact the state wants to bring it, they'd have to have evidence to prove beyond a reasonable doubt. So I guess I would lean that way until convinced otherwise by our witnesses as they come in.
Senator Rose?
I'm trying to understand if the evidence can still be used in a later thing. I'm trying to understand your reasoning, because initially I thought that your reasoning was that it would be without prejudice because that evidence couldn't be used if other things happened, but now you're saying it can be, so I'm confused.
It depends on what the evidence is, but the question is, should the charges be refiled? So if somebody is stalked and then found, and then the person is found not competent, and then several years later, case gets dismissed, but then that same person against their former victim kills them or kidnaps them, I think it's reasonable to be able to refile charges that are related to that.
I guess if I might interject for a moment, I think the point too is that stalking is a great example because that generally requires a course of conduct. So I think the point is that even though you can't refile the charges, if it's dismissed with prejudice, you can't refile the charges based on that first incident, stalking or whatever it may be. You can't refile those charges if it's with prejudice. But if there's some future crime that the person's charged with, in which their prior conduct may be relevant, and that's Senator Hashim is saying, the rules of evidence are very strict about when prior conduct can be used, but there are some certain situations, course of conduct, character evidence you mentioned. You know, if someone could, prosecution were able to successfully argue that under those circumstances, some prior conduct could be admitted, then yeah, I think that the prior conduct, that even though they can't charge them with a new crime, the conduct itself might be admissible under one of those theories. Again, that's generally difficult to show, but possible.
Yeah, I guess if someone has escalated and is now being charged with a much more serious crime, I guess I don't know what the point is in charging them with a maybe 10-year-old previous thing that they weren't competent for if they're facing charges for something much more serious. That would carry a heavier, I'm just trying to understand.
They're not being charged with it though.
No, but if someone goes down the road to kidnap someone, they're now being charged with kidnapping, they're facing much more serious charges, much more serious consequences. What is the benefit of also saying, oh, well, 10 years ago, we're also gonna charge you with this thing you did and we're found incompetent to stand trial for? That was not as serious. Like, I don't understand what the value is in doing that.
So if we're talking misdemeanors, it'll be 2 years, as long as it's still within the statute of limitations. But I mean, if it's instances of stalking over the course of several years that have then led to a person being kidnapped or sexually assaulted or murdered, and you want to charge the person, bring back the charges that were previously dismissed without prejudice, I'm not sure why you wouldn't want to do that if the reason that they're being dismissed is only because the time limit ran up and not because of a deficiency in the actual merits or the actual case itself when it was first brought.
Just to throw this piece in the example we're talking about, if you have a pattern of stalking, it seems to me that a judge in that instance would find that it's contrary to the interests of justice to dismiss with prejudice, or might probably do so because it's clearly a level of danger beyond other misdemeanors. So I guess for me, I'm willing, in the interest of not having these cases littering the system, this seems to me like a way to provide the court with a tool to get rid of cases that have already gone on too long. The time is greater than the maximum sentence for the offense. So given the discretion of the court to act not to dismiss the charges if there's a situation like the one mentioned, I don't see why we would make all of the dismissals without prejudice, because in some ways it's a philosophical thing where if you're a prosecutor, I think you would always want to have the ability to bring charges back. If you're worried about the health of the system and what's clogging it, as well as how to protect people, I think this language does a good job of threading that needle. But that's my current thinking. Willing to change if witnesses present otherwise.
Just wouldn't be clogging the system without prejudice. I mean, okay, so here it is, shelved someplace.
Yeah.
So it's not clogging anything, so if you want to come back and revisit it.
Yeah.
But in the interim, it's not clogging anything.
Fair enough. I guess it would depend on how many are brought back. I just think if somebody's waded through the maximum sentence for the offense, to then bring them up on a misdemeanor, put them through a trial, and then sentence them to that time again, I don't know why we.
Yeah, well, and especially in the instance we're talking about, they're facing something that would be a much longer sentence anyway.
Right.
So I just don't understand the value add of being able to bring back a misdemeanor. It doesn't make any sense to me.
Well, we introduced to our witnesses.
Exactly.
Well, whatever way the committee goes, it'll be very easy drafting. So just keep me posted.
I'm afraid that witnesses will ruin our opinions.
There's also that possibility.
Wait a second.
Yeah.
I don't have any other questions. Good to go for the next.
Okay, sure. So now we're moving kind of into track 2. We were just talking about, you get to the forensic facility if you've been found incompetent to stand trial for an offense with a lifetime maximum, and you're not already civilly committed, right? You're already sitting in that process. Now we're going to track two. Another way you get to the forensic facility is you're found not guilty by reason of insanity. And that's different than a competency proceeding, because we think for a moment, and it's important difference. In a competency proceeding, criminal charges are still pending against you. We're just talking about when they might be dismissed, but assuming that doesn't happen, the criminal charges are still pending. So the criminal division still has jurisdiction over you, can send you to the forensic facility in a much more direct fashion. This situation is different. Someone's found not guilty by reason of insanity, that's a complete defense. So that person no longer has charges, criminal charges pending against them. So the language, though, provides, and this is a very important constitutional piece we're going to need to talk about for a minute, starting on line 11. Person who's charged with an offense punishable by life sentence and is found not guilty only by reason of insanity shall be committed to the forensic facility. So, right, if you're taking that person, committing them directly, person who at that point would otherwise be subject to the civil commitment process, right? Because there aren't any criminal charges pending anymore. The only reason to get that person committed somewhere would be through the civil commitment process, which you may remember from the very beginning of our discussion today, requires a burden of proof on the prosecution by clear and convincing evidence that the person be committed. So, very different for a not guilty by reason of insanity person, and as you might expect, question has come up constitutionally, is that consistent with due process or not? Because that's not, certainly not, as I think you've heard other witnesses testify, not the way the constitutional requirements work in the civil commitment process. The Supreme Court has carved this proceeding out, though. In a case called Jones v. United States from 1983, the court specifically said when a criminal defendant establishes by a preponderance of the evidence that he is not guilty of a crime by reason of insanity, the Constitution permits the government, on the basis of the insanity judgment, to confine him to a mental institution until such time as he has regained his sanity or is no longer a danger to himself or society. This holding accords with the widely held and reasonable view that insanity acquittees constitute a special class that should be treated differently from other candidates for commitment. Keep bear that in mind, though, because that sort of underlies all of this. Because as I think you heard from your Attorney General testimony last week, was correct, which is that this sort of seems counterintuitive in some ways when you look at the process and see how can this be made? Well, the court has held that it is permitted under the due process clause, and the reason, the rationale behind it is that in contrast to a civil commitment proceeding, where the person is being, in a sense, really brought into the court for the first time to decide whether or not the person should be essentially committed against their will, involuntarily. In a criminal proceeding, the person has already been found not guilty by reason of insanity, and that's a defense. The person themselves has successfully proven to the court that they did the crime, but they were mentally ill. So the court said that can really sort of satisfies due process, because it's a different type of finding that has to be made with respect to this one particular class of persons. So that's sort of the rationale, and it's now quite well established. This sort of proceeding where this person, if you look at it, goes right to the forensic facility, is permissible under the Constitution.
Yeah, I understand the civil versus the criminal, whatever else. What I didn't understand in their ruling was they based it on using preponderance of evidence. Why is that if it's a criminal?
Well, yeah, they said the same thing. They didn't. It's interesting. We'll get into that, but I'll sort of preview it right now. That the question of the standard of the burden, who bears the burden, and under what degree of evidence the court has looked at, they haven't clearly resolved those. They have resolved that it's permissible. Now, the two main Supreme Court cases on this both involve cases where the defendant, the burden shifted to the defendant to prove by a preponderance of the evidence that they weren't dangerous and they weren't mentally ill. The same way the bill does. Remember, that's, you've noticed that. If the burden shifts them. So the court didn't specifically say it. There have been some different decisions as to what that burden should be. But generally speaking, I think the court did say that the different preponderance versus beyond a reasonable doubt versus clear and convincing, that's another reason that because of the difference with respect to these not guilty by reason of insanity defendants, that it's okay for there to be different standards of proof. They did say that. They didn't specifically identify what was okay and what wasn't. Although I think by implication, you could at least say that it's okay to shift the burden.
This is the plot of One Flew Over Cuckoo's Nest, One Flew Over Cuckoo's Nest, where McMurphy is in prison and then he figures out a dodge, which is he'll plead insanity and he gets transferred to the mental hospital, but he thinks he can get out after a finite period, but it's whenever they judge him to be sane. And then he realizes that he's in a worse situation because they'll never find him sane. So he's basically got a life sentence now, whereas before he had a 5-year sentence or something like that. So the part that gets me is found not guilty shall be committed to a forensic facility pursuant to this section. And then there's nothing that at that point gets them out if they're found continuing.
There is now,
There is now.
yes.
Is that in here?
I added it, yes.
Oh, where?
That is, and I didn't just add it, that, by the way, I didn't just
Yeah.
come up with that. I spent a lot of time this weekend looking at other state statutes because virtually all of them have them, Vermont doesn't, and constitutional cases that have come up under this, and there's a lot of those. And part of the reason for that, if you think about why there's a lot of deprivation of due process happening there, so it makes some sense that there would be a lot of cases. But also, as I said, particularly with respect to the burden of proof, since the Supreme Court cases aren't entirely clear, there have been a lot of lower court cases, not just in the federal courts, in a lot of different state courts, under state constitutional due process provisions as well as federal ones, challenging this whole idea of shifting the burden, what should it be, preponderance, clear and convincing, that sort of thing. I just want to put that out there too, because I think that whatever direction the committee goes, if you pass this, you can be certain that it will be challenged. And at least in part because it hasn't clear in Vermont yet. There isn't such a, it's been in existence in other states, so there have been opportunities for the defense attorneys and public defenders to challenge them. It hasn't happened in Vermont yet. And since it's not entirely resolved, at least the part about the burden of proof and that sort of thing, if that isn't fully established, well, even if it was, isn't fully established under the federal constitution and hasn't even been raised under the Vermont constitution yet because the process doesn't exist yet. So it would almost be, it would be incumbent on, it's going to be raised. You can be sure of that. And that doesn't mean you can't do it. It just means it shouldn't be a surprise if that happens. Doesn't mean it was poorly drafted.
Eric, are you pointing to, on page 5 and following, the person establishes by clear and convincing evidence?
Yeah, so here, I'll describe it for a second
Yeah.
before I look at the language. So here's the way it works. So they get found not guilty by reason of insanity for one of these life maximum offenses. They get sent to the forensic facility. Within that first 40 days, unless the court extends it for good cause, which they can do, but within that first 40 days, there has to be a first hearing. Okay, at that first hearing, this is over on page 5, line 15. Court shall order the person committed, unless the person, this is line 16, 2 crucial highlighted pieces, because this is your decision points. Unless the person establishes by clear and convincing evidence, so A, the burden is shifted to the person, and B, it's by clear and convincing evidence. Quick background, as I said, I looked at a lot of these statutes. I didn't look at all 49 of them, assuming I don't know that, there isn't quite enough time to do that, but pretty much all the statutes I looked at did shift the burden to the person. There's a couple of exceptions, Virginia, and New York was a little hard to sort of decipher, but I think at least part of it, the state still had some of the burden. But the others, they all shifted it to the person to prove. Also though, interestingly, by clear and convincing evidence. Again, I didn't look at all of them, but other than the federal statute, which is clear and convincing, all the state ones I looked at were preponderance. There's a lower threshold for the person to have to prove in order to get out. See what I mean?
Well,
So
it just seems
again,
like
these are policy points for you. So
seems like a difficult thing to prove by clear and convincing evidence. But for you yourself or your attorney to prove by clear and convincing evidence that you're no longer suffering from a mental disease, Because there's just so much ambiguity involved. But anyway, my further question would be, so this is a hearing, it puts the burden on the person to establish that they're no longer insane. Can they just be held forever?
No.
Or there's no clock that runs?
Well, there is, so then what happens after that is that the person, so there's been two other reevaluations of the person that will take place for sure for one of them, assuming the person files. But the way it works is, and this is also based on other states, and this goes over onto page 6 and 7, which is that the evaluation of the person's sanity can take place again under two different circumstances. One is Commissioner of Corrections, based on the certification from their clinical services director, the person is no longer suffering from it. So the clinical services director, after treatment, which I also added, you'll see, remember, there wasn't any treatment piece before, but that's in there now, based on the Washington statute. The clinical services director says to the Commissioner of Corrections, this person looks like they're no longer criminally insane. Then the commissioner has to request a reevaluation by the court. So that's one circumstance.
Mm-hmm.
Circumstance 2 is the person can request it themselves every year. So that's page 7, lines 5 to 10. So the person can continue to request it annually. They want to be reevaluated. And that's based on,
So
I think it was Hawaii.
In effect,
Yeah.
they have a life sentence with possibility of parole.
Well,
In other words, they're not going to get out unless they convince a board or a
The court.
Well, first a clinical services director in that one instance,
right.
and then convince the court. Yeah, and maybe there's no way around it, but it does seem like once a person is in there, they're in a gray area. That clear and convincing evidence seems like it would be a high bar to hit there, but anyway.
Well, as I say, that is a constitutionally permissible, that doesn't mean it's required. So it's up, you guys can make that decision. And even just one last, sorry to interrupt you, just because it's a fun little, my lawyer geeks coming out. But, so the specific federal court in California said on the basis of the other main Supreme Court case on this is called Fuchsia v. Louisiana in 1992. And this federal court said specifically that the court's analysis, and not analysis, but the decision about what is the right standard of review and who the burden should be on is admittedly, in the light of those two Supreme Court cases, admittedly subject to different interpretations, and lower courts analyzing it have reached different results. So that's just, so you know that you have some decisional ability there as to what you want that standard to be and who you think should have it.
Senator Rose.
So I am, it's sort of a similar area of questions. And so the person has to convince whomever needs to be convinced that they're no longer insane or they're no longer a danger to themselves or others, because presumably someone could be not dangerous and still suffering from a mental health or disease or defect.
Yeah, I was sort of using it as shorthand, and perhaps I shouldn't have, but no, what they have to convince everyone, the court, that they're no longer suffering from a mental illness that would create a substantial risk of bodily injury to another person.
Okay.
So it's both.
Okay.
And that, so it's both.
Okay, because I had concerns if it was just that they were no longer suffering with a mental disease or defect, or however that horrible language is in the law.
Mm-hmm. Right.
Because there are lots of people that struggle with mental health challenges that, in fact, most people that struggle with mental health challenges are not dangerous.
Right, and that actually is that second Supreme Court case I mentioned, Fuchsia v. Louisiana, was exactly, that was the issue. Could someone be held on the basis only of dangerousness without requiring mental illness? The court said no. To hold somebody, you have to show both, that the mental illness and that they're dangerous to another person. That's the only constitutional way to do So,
You can't hold someone just because they have a mental health issue or just because they're dangerous.
Exactly.
Okay,
it's gotta be both.
okay. The shorthand got all my
Yeah,
hackles
sorry
up.
about that.
No worries.
Yeah.
That was a point I was
Not sure about the dangers.
also concerned about as well. And I mean, the way I'm reading the case, just the orders and this bill is that, as you said, if there's a substantial risk of injury to somebody else and it's a result of the mental defects as it's being described, but just having that illness isn't what keeps you.
Exactly,
Yeah.
exactly. No, it has to be both, for sure. And both, and that they're connected. It's the mental illness that causes dangerousness.
Oh, and actually the other piece, I couldn't find it. I think you had mentioned that there's a year timeline that a person is permitted to move once a year.
Yeah.
Page 7.
I didn't see that on, we're on page 7.
Senator Norris may be right, where it's in here somewhere. Oh, here it is. Oh, on mine, it could be different drafts here. I'm on page 8, lines 5 through 7. And this is based on, you could do whatever time period you wanted. Hawaii had a year, but I think the Wyoming statute has a funny one where, like, if you do it more frequently than every 6 months, then the court can make a summary finding. So it's just sort of a middle ground.
I didn't mean to jump too far ahead. I just wanted to
No,
clarify where that was.
No, that's an important point, because that's part of the whole process.
Did you have a question?
Yeah, and it's sort of around the constitutionality of limiting how often someone can say, hey, I should be released.
I think it's pretty common.
Okay.
I'll see if there's been any cases on that specific point, but I think in this context, because the court has been so clear about the different standards that apply in the not guilty by reason of insanity situation, that they've also talked about other timelines, not specifically that, but other timelines being different. I know I saw a couple cases on that, like being able to recommit somebody on a different standard and on a shorter timeline. So I don't know, and we'll look to see if there's any specific cases, but I think kind of their general approach of saying this is a very narrow carve out and specific one, that would at least arguably be permitted.
Yeah, and I understand, the constitutionality and rationale behind, saying someone can only petition for parole, but this is clearly not to be a punishment. It is not to be so I don't know. I'm glad to know that. I mean, I don't know that I'm glad to know this, but I've got questions there around, because it seems to me we're sort of aligning it with the limitations on asking for parole. And that to me seems to be kind of yet another indicator that we're sort of treating it like jail. And so that just raises concern.
Sure.
So just so I'm clear on this, I'm going to back up a little bit.
Yeah.
You said the two-pronged test was to make sure that someone was suffering from a mental illness
Yep.
and dangerous. You had to prove both of those. So if in fact you can show that they no longer suffer from a mental illness, but they're still dangerous, they can be released.
Correct.
Wow.
That's what happened
That's
with Fuchsia.
justice.
Right.
Okay, as long as I'm understanding that.
That was the exact case.
Isn't it like that with bail too? That someone, it can't be, or am I?
I think bail at dangerousness is.
That you can be held.
Right.
Yeah.
But I think not,
Well,
I don't
bail,
want to speak up the top of my head, not just, life, it has to be a life, right?
my understanding
The
of
court is
bail
defined.
is that you can hold without
Right.
if someone is dangerous and no set of circumstances can mitigate that dangerousness. You actually may not use bail to mitigate dangerousness. So I can't say, oh, you're dangerous, so you get $1 million bail, and you did the exact same thing, but you're not dangerous, so you get a $10 bail. bail can only be used to mitigate risk of flight. We've spent so much time on bail in this committee.
Yes, I think that sums it up nicely.
Okay. Now, in an instance like Senator Norris what do you do? What do you do in the instance where the court deems, nope, you are no longer insane, you're still dangerous? Like, is there anything you can do?
You could civilly commit the person.
But wouldn't that also rely on them being mentally ill?
Yes. But you might also be able to show developmental disability. You know, the civil commitment process is different, and there's a number of, I don't have the statute right in front of me, but there's a list of ways in which statutorily you can be permitted to show both likeliness of harm to yourself or others. And there's some criteria in there, so that may be a different factors that would go into a decision in the civil commitment process.
But I mean, I guess it happens through the criminal justice system too, where someone is sentenced to say 10 years, they've served their 10 years, they're still dangerous and they have to be released.
True. Yeah.
Can we keep
Promoting
going?
longer jail sentences?
I am not.
Can we keep going with the walkthrough here?
Yes. So we sort of covered pieces of this already, but we kind of have the big picture of what happens. The person's found not guilty by reason of insanity. They're sent to the forensic facility. There has to be this hearing within the first 40 days. At the hearing, the person bears the burden of proof by clear and convincing evidence. They have to establish that they're no longer suffering from mental disease or defect that would create a substantial risk of bodily injury to another. I'm on line 19, page 5. Just to remind the committee there that, remember, the last draft had included property damage, so that's being struck in every instance. There has to show the person as a risk of harm to another person, not just property damage. Turn it over on page 6. The person does establish that by clear and convincing evidence that they're not mentally ill or dangerous, then the court releases the person. That's 4 and 5, right? So you sort of think what could happen. If they establish that, they get released. If they don't, then they get committed to the facility.
I'm just reading this. So it now says, if the court finds that the person has established by clear and convincing evidence that the person is no longer suffering from mental disease and upon would create a substantial risk of bodily injury to another person, the court shall enter an order releasing the person. That's correct? That's not missing a not there on line 3?
I think so, because it goes back to line 2. The evidence the person is no longer suffering from a mental disease or defect, that would create a risk of bodily injury.
I see.
So they're no longer suffering from a mental illness that would be dangerous, to kind of use shorter words for the moment. Then the court releases the person. I remember if they don't show that, then they're at the forensic facility, and then subsection C goes on to say, generally speaking, this is your point, Senator Baruch, placement is generally for an indeterminate period, provided that, and this is a point, first, the trigger for the release is the next sentence. They have to establish by clear and convincing evidence that the, again, same language, no longer suffering, etc. How do they establish that? That's going to be either because the Commissioner of Corrections has to file a petition. That's the very bottom of page 6 over on page 7. The Commissioner of Corrections has to go to court. If the Director of Clinical Services says we think this person isn't suffering anymore, Commissioner has to go to court, bring the petition forward, or the person can do it every year. So we've talked about that piece already.
On page 6, line 11.
Yep.
Should we be eliminating serious damage?
Oh, thank you. Nice catch. Yeah. Thought I had covered those. Thank you. New language, subsection D, page 6. This is the issue the committee was concerned about. I think Senator Wachowski was kind of getting at it as well, which is, you know, is it a treatment facility supposed to be, not a correctional facility, right? But the previous draft didn't have any language about the treatment that the person was supposed to get while they're inside. So this language is from the Washington statute. Makes clear that the commissioner shall provide adequate care and individualized treatment at the facility to persons who are ordered committed there. In order that the commissioner may adequately determine the nature of the person's condition needs, all persons shall be promptly examined in order to provide a proper evaluation, diagnosis, and treatment. So just some general language about making sure that the treatment is happening. But as I say, I tracked it on language from a different state.
And Washington locates their non-jail treatment facility in their jail?
No. In fact, I didn't look at all 50 states, but all the ones I looked at had a separate psychiatric facility.
I still have pretty significant concerns with DOC being involved in something we're claiming is not a jail. But thanks for that language is important that you have there.
Right. Let's see. So we've gone through page 7. I've gone through all that. As we just said, that the corrections commissioner has to file, and the person can file every year. And then bottom page 7 over onto page 8. In these subsequent evaluations, if they take place, again, it's the same standard. The court must order release if it finds that the person is no longer mentally ill and dangerous. Over onto page 8. Page 8. If the court finds that the person is still dangerous and mentally ill, then they deny their petition for release and they order them commissioned for treatment. And then you'll see, committed for treatment. And then you see lines 5 to 7 to the point that if they deny the petition, then they can't bring another one for another year. So that's successive petitions, that's sometimes called, sometimes in some places of the law. Subsection E isn't changed too much, but this is just the idea that if the person is released, then the Commissioner of Corrections has to monitor their compliance with the conditions of release. And they may return the person to the facility if they're non-compliant, in which case they'd have another hearing to determine whether they're non-compliant and dangerous. Over onto page 9, we looked at this at the very beginning. This is the definition of forensic facility. Again, reordered to stress the secure treatment in subdivision A. Similar language in subsection B on page 9 says that the definition, subsection A, the requirement of subsection B, the Commissioner of Corrections shall establish and operate a locked, secure forensic facility for the, and again, that's why I've added the treatment language again, for the secure evaluation, treatment, and care of persons down onto line 18 who have been transferred pursuant to, and those cross-references are the two competency and not guilty by reason of insanity tracks that we just talked about. So they're going to be transferred to that facility one way or the other. And that's just saying for those people, corrections has to establish this facility for their evaluation, treatment, and care.
Eric, if I can add real quick and also up to the committee's opinion on this. For line 14, where it says the Commissioner of Corrections shall establish and operate, so on and so forth, inserting in consultation with the Department of Mental Health. So it would read, the Commissioner of Corrections in consultation with the Department of Mental Health shall establish and operate a secure forensic facility. Shall establish and operate a locked and secure forensic facility. I think that is geared more towards the rehabilitative aspect of this that we have to have. And so just a note for future markup, unless there's different thoughts on it.
Sure.
I just have a question. Are you suggesting just here or in every place where we're tasking the Department of Corrections or the Commissioner of Corrections to do this work? Because I mean, it also raises question, like, why would it be the Commissioner of Corrections that's arguing that this person is now sane and not the Department of Mental Health? Why would it be? So I'm wondering if that, I mean, it doesn't, I think it's better, but it still doesn't solve the concern I have about why corrections should be involved at all if it's not jail. But I do think that is a good point that the Department of Mental Health should be involved.
I think so I mean, since we're under the definition for forensic facility, I think that, I mean, they're both departments under the Agency of Human Services. So, I mean, should it just be the Agency of Human Services provides for the secure evaluation, treatment, and so on? Or I mean, what will be, I'm just trying to think of what the impact will be if we were saying that the Commissioner of Corrections will consult with the Department of Mental Health versus the Department of Mental Health shall consult the Commissioner of Corrections and so on. I mean, if we're talking about a locked and secure facility, that is under the umbrella of the Department of Corrections. We're talking about mental health, obviously under the Department of Mental Health. And so perhaps is there a way to word this generally throughout the bill so that it's clear that this is more of a partnership between DOC and DMH? That way we're getting at both the secure facility aspect of it as well as the mental health recovery aspect of it.
We'd have to look at the bill overall. I think in some places where, for example, you're saying that the Commissioner of Corrections has to file a petition for release if the clinical services director has said to them, I mean, maybe you could add in consultation with DMH, but other places it might be a little clunky.
Would that clinical services director be a member of DMH?
I don't think it's written that way. But again, you could ask, I think they're both coming in, so maybe see what they think as far as the best way to structure that.
I recall hearing from DOC that they would run this through WellPath, so the clinical director wouldn't be a state employee, it would be a for-profit contracted.
Got it. Okay. Did you raise your hand? Okay. Thank you. Okay, well, we'll put a pin in that as a decision point.
Yep.
For later.
I have a question about
Senator
page 10. This is the public records and confidentiality. It says they'll be exempt from public records, etc., shall be kept confidential, except that records shall be made available to the parties in the underlying criminal case upon request. So that would be the state's attorney and others in the underlying case. Could a later prosecutor who's looking at something with this individual, could they look at these records? Because it seems like it's limited to the parties in the underlying criminal case rather than cases that might come along later involving that person.
That's the way I would read it. Yeah.
I'm just wondering if that's too restrictive. In other words, I remember when we were doing the sealing, the state's attorneys were very protective of their ability to go back and look at previous cases. It seems like here we're explicitly forbidding that, which seems like it could be an issue since you're dealing with the tiny percentage of people who have been judged a danger to society. So I just put that out there for maybe the witnesses to respond to.
Right. Yep.
I have the opposite concern, and I'm curious how this squares with HIPAA, that you could ever share someone's treatment information with their protected medical information on a case that has been dismissed. Or not dismissed, but yeah, it has, it's been dismissed. Like I am really, and I hear you, but HIPAA protects medical information. If this is not a jail and this is treatment, that is all protected medical information.
I have a pretty expansive view of the HIPAA state law exception. So I think it hasn't been, has talked sometimes in the legislature, but my reading of HIPAA is that I'm not commenting on the policy. You got, whatever policy you think it should be. But HIPAA has a specific exemption for required disclosures by state law. So if the state law requires that certain information be disclosed, in my view, it trumps HIPAA. So have a look at that quite in detail, and I've got a couple cases that say that. So again, state law doesn't say that very much. It's a policy matter. If you wanted to say that, then you can require, not permit, but if you require disclosure of records by state law that aren't otherwise privileged, then HIPAA wouldn't stand in the way.
Huh.
I can email you the legal research I did, and that'd be helpful.
I believe you. Gives me a lot of concern, because I mean, as I hear that, we could just decide you have to share whatever, like, well, we don't like this particular group of people, you have to share their medical information, like that feels horrifying to me, but I do believe you.
Well, it's been an ongoing issue for a number of years.
Okay, and is it fairly settled or?
I don't know.
Okay.
I don't think that it's always settled from the perspective of the executive agencies. But from my perspective as an attorney for the legislative branch, I think it's pretty clear. The legislature has that ability.
I think one question that could be discussed between witnesses, hopefully, is, how this evidence would be used in a hearing to determine whether or not somebody can be released after this, because what I've seen is situations where the state doesn't have access to information that may change their opinion as to whether or not somebody should continue being held. And then I guess it lands to the defense attorney as to what amount of what evidence they'll admit in order to try to get their client released. But then the state doesn't have access to it at the same time, unless it gets admitted. So it's a complicated rules of evidence piece that, is a bit beyond me, but it's, I've seen it get very complicated, is all I'm trying to say.
Yeah, the fact that they might not be confidential doesn't necessarily mean that they would be admitted. You're right, that's another complicated hoop that would have to be jumped through in order to find it is relevant and not prejudicial, all that. Yeah. But that's no changes to the other language you've seen before is hasn't been changed. The fact that the department has rulemaking authority over this facility and is required to establish rules to cover the operation of the facility, and that there's an exception to the rules of criminal procedure that the rules of evidence that provides that they don't apply in proceedings concerning, this is over page 11, line 7 and 8, competency restoration proceedings or granting or revoking conditional release. These type of proceedings we just talked about, that the rules of evidence don't apply in those proceedings. So that a wider degree of evidence could be looked at.
Yeah, just back on page 8, line 14, a grammatical one.
Yep.
I have the commissioners shall notify the court where the person was.
Oh, yes, nice catch. Thank you.
Look at that.
You got it.
Shocking.
Yeah. That's all right, thank you.
I feel good about that.
All right, so the decision points that I have listed so far, should this be attached to a jail? Yes or no? And then should this be under the purview of DOC or DMH or the Agency of Human Services, or should we just say the DOC in consultation with DMH or vice versa? That's the next decision we're going to have. And the third is the clear and convincing burden, the clear and convincing threshold, and then who the burden rests upon. And then I guess there's also lingering questions regarding when the 7553 hearing would get held, which is a hold without bail hearing.
And also the question about who can access the records going forward.
So I don't know that we necessarily made any substantial markup requests for today, but I think, so I know we have, actually, committee, are there any other decision points that are left?
Did you mention with prejudice, without prejudice?
No.
Senator Sheen, could you ask you a favor? I got picked up with your one, with item number 3 and I missed 1 and 2, sorry.
No problem. So the first question was whether or not we should specify in the language that this will not be attached to a DOC facility. the
Okay,
jail.
yeah.
And then the next piece was the wording around whether or not this is under the purview of the Department of Corrections or the Department of Mental Health, or do we say both?
Yep.
Or do we say Agency of Human Services? And then the next was the clear and convincing evidence
Yep.
threshold, and then the burden, and you had that one, so.
Yeah.
And then after that, who can access records? And then dismissing misdemeanors with or without prejudice.
Mhm.
And then
Thank
somewhere we'll have to add clarifying language about hold without bail hearings.
Great. Great, thank you.
Did Jenny say that she wants to come in tomorrow at 10:15? Is that what you said? Eric, would you be able to come in tomorrow at 9:30 so we can continue working on this?
Yeah, sure, yep.
So we'll do 9:30 tomorrow, markup, and hopefully we will have reached decisions on these. Actually, let me back up a bit. We're hearing from a number of witnesses on Thursday. And I think, well, I'm assuming their testimony will determine or affect our decisions on those decision points. So perhaps we shouldn't do markup tomorrow morning. And I'm trying to think here. We do have Jen Coleman coming in tomorrow. Okay, well, I just have to do some agenda work.
Okay.
So I don't think you have to come in tomorrow morning. I don't think that would make sense. I think we should hold that until after all the witnesses we're hearing from on Thursday.
Right.
And yeah, okay.
Well, I'm flexible in the morning, so if it turns out that you're making some adjustments, just let me know. I can,
Yeah,
it'll work for me.
yeah. Maybe we'll hear something. Maybe we'll get some emails or something after this. After we just had this hearing, and that'll provide some help for us. But we'll let you know in the morning.
Okay, sounds good.
Okay, great. Thank you. All right, we can adjourn.